Recently, a viewer sent me a private message saying he's going through a really tough situation. He's living with his boyfriend, and the guy is in the process of getting a divorce. Right now, they're living in the house that the boyfriend bought with his ex-wife, and he's started helping to pay the mortgage. But the thing is, this house was bought during the boyfriend's marriage, and the ownership is only under his name. So he asked me if there's any way he could get his name added to the property. Can the money I'm putting in now count towards a share of the ownership? This is a very typical but also very risky situation. So today, let's use this story to talk about the rules around matrimonial homes in Canada and how parents or individuals can actually protect their financial contributions. First off, what exactly is a matrimonial home? In Ontario, Canada, as long as it's the main residence where a married couple lives together, the law considers it a matrimonial home. This means that regardless of who bought the house or whose name is on it, as long as you both lived in the property after marriage, when it comes to divorce, it counts as part of the joint net assets. The net value of the home has to be split 50-50. Selling the house also requires the mutual consent of both spouses. A lot of people have a misunderstanding. They think that buying a house before marriage means they're in the clear. Many people believe that if they buy a house before getting married, pay for it in full, and finish all the payments, then it shouldn't be divided in a divorce, right? But the truth is, as long as you both lived in that house after getting married, it no longer qualifies for the premarital asset exemption. For example, say you bought a house for $800,000 in full before marriage. After getting married, you both live in it. By the time you divorce, the house has appreciated to $1 million. What you get to keep isn't the original $800,000, but only half of the net value, which is just $500,000. The net value of the entire house has to be included in the division. So how can you protect yourself in advance? This is where a prenuptial agreement comes into play. The most common and also the most effective method is this prenuptial agreement. In the agreement, you can clearly specify who contributed the funds and what the market value of the property was before marriage. For example, $800,000. When you divorce, this amount will be excluded from the division. Keep in mind that Canadian law protects the amount of money, not the house itself. So even if you paid for the house in full, have it under your name, and paid the mortgage by yourself, any increase in value after you move in together post-marriage still has to be split equally. If you didn't sign an agreement before marriage, there's still a chance, as long as both parties agree, you can sign a postnuptial agreement after getting married. A postnuptial agreement is used to confirm each person's contributions and rights. But with a postnuptial agreement, both parties must voluntarily obtain independent legal advice, and the agreement has to withstand court scrutiny. So, in practice, it's more complicated. Now, going back to the question from the lady earlier, she's currently living in a marital home jointly owned by her boyfriend and his ex-wife. As for the property, during the asset division process, she likely won't be able to have her name added to the title. If the loan repayments he made aren't documented in writing, they're very likely to be considered a gift with no expectation of repayment. In the end, he might not get anything back and could get caught up in a complicated divorce dispute. What's even more crucial is that Canada has a no-fault divorce system called no-fault divorce, which means that even if a spouse is at fault, like cheating, it won't affect the division of property. And there's also no such thing as the cheating party having to leave the marriage with nothing. So, if the main contributor to the marital home happens to be the one who was hurt, and there's Northwest agreement in place, the outcome could end up being really unfair. If parents are contributing funds, or you don't want to sign a prenuptial agreement, there are also some lower risk options. For example, parents can buy a house after the marriage, but not use it as the marital home. Second, the property can be registered under the parents' names, and the child and their spouse can sign an agreement to pay rent. Third, if parents give cash after the marriage, as long as it's not used for the marital home and is kept separately, this money usually doesn't need to be divided. These methods aren't foolproof. While they can't guarantee absolute safety, they're still much safer than blindly contributing money. It might sound a bit complicated, but these arrangements are so much better than ending up with nothing and regretting it later. In Canada, the net value of the marital home is split equally, regardless of whose name is on the title, who paid for it, or who was at fault. Protecting your home depends on having things clearly written down, not trust or verbal promises. Use structures to separate risks. Don't let good intentions turn into a costly lesson. I'm Priest, your first-time home buying and selling expert in the Greater Toronto area. If you're planning to buy or sell a home, reach out to me to discuss the safest approach. See you in the next video.